MassComm 101, Quick and Dirty, Chapter 13, Media Law. Free press versus fair trial. Not only is the First Amendment in the Bill of Rights, so is the Sixth Amendment. The Sixth Amendment is the right to a fair trial. And when you have a possible conflict between the freedom of speech and freedom of press versus the right to a fair trial, there have to be some compromises. In 1966, the U.S. Supreme Court carved out one of those compromises. Sam Shepard was a doctor, an MD. In 1954, his wife was found dead in their Cleveland area home. There was some circumstantial evidence at the scene that implicated Dr. Shepard. Well, police did not make an arrest for a while. They were gathering evidence. And during this time, there were newspaper columnists and others who were openly campaigning for Dr. Shepard's arrest. Well, eventually Dr. Shepard was arrested. And by the time that it was ready to have Dr. Shepard's trial, the jury pool was terribly tainted. All of the people who eventually got picked for the jury, except for one, had heard some of that prejudicial publicity, read it in the newspapers, heard it on the radio, and elsewhere. Furthermore, once Dr. Shepard's trial was underway, jurors were able to go home at night, and they were able to be exposed then to even more prejudicial pretrial or prejudicial publicity during the trial. Well, Dr. Shepard was found guilty and sentenced to life imprisonment. After many appeals, please note the original murder was in 1954. After many appeals, in 1966, the Supreme Court overturned Dr. Shepard's conviction. The court was not saying that Dr. Shepard was innocent. It was saying he didn't have a fair trial because of prejudicial publicity. So, why the Supreme Court made this decision was to give lower courts a set of tools that they could engage to make sure that defendants would have a fair trial. So from that decision forward, judges have the right to change the venue, the location of a trial. Now that hasn't always worked out in a way that many of us feel was good. In the early 90s, there were police officers who beat an African-American motorist named Rodney King. And when it was time to put the police officers on trial, the venue, the location of the trial, was moved out of Los Angeles County, which in itself wasn't so bad. I mean, there was a lot of publicity about this. But where it got moved was just over the Ventura County line into Simi Valley, a very conservative community that just so happened to contain a lot of law enforcement families. So judges can change the venue of the trial. Maybe we don't always agree that it's a good thing. Oh, and by the way, the police officers were not convicted in that Simi Valley trial. Another thing the judge can do is to sequester the jury. In other words, during a highly publicized trial, the jury is to be put in a media-free bubble for the duration of the trial so that they don't hear things, read things, see things that would not be admissible evidence in the trial. Furthermore, judges have the right to issue a gag order to trial participants, witnesses, attorneys, bailiffs, jurors, experts brought in to testify, and so on and so forth. And a gag order means you cannot talk to the media about the trial until it is over. Is that an abridgment of freedom of speech and freedom of press? Yes. But the Supreme Court said it is necessary to do that in order to give defendants their Sixth Amendment rights. Another issue in regard to free press versus a fair trial, is whether cameras should be allowed in the courtroom. And if they are, under what circumstances? Charles Lindbergh was an American hero. He was the first person to fly an airplane across the Atlantic Ocean, did it in 1927. Mr. Lindbergh's fame would eventually dim. As World War II loomed, he was distressingly pro-Nazi. But Charles Lindbergh was still a national celebrity in 1935 when his infant son was kidnapped. It was one of those stories that today we would say it went viral. In other words, everyone was talking about it. A local handyman named Bruno Hauptmann was put on trial for the Lindbergh baby kidnapping. I have no idea whether Mr. Hauptmann actually kidnapped the baby. By the way, the body was never recovered. Hauptmann did send a ransom note. So in that supercharged, highly publicized situation, Hauptmann, it appears, probably tried to cash in on the Lindbergh's misfortune. That doesn't mean he actually kidnapped the child. Well, Hauptmann's trial was not the best of American justice. There were movie cameras all over the courtroom. They needed banks of bright lights. There were cables all over. Newspaper photographers had the old speed graphic cameras that shot flash bulbs that would have a burst of light and blind people momentarily. It was kind of a circus-like atmosphere. And Hauptmann in that trial was found guilty and was executed. The American Bar Association just had a bad feeling about that trial, and issued an advisory. It was called Canon 35, and the American Bar Association said to the states, you really should not allow cameras in the courtroom. They are disruptive. And so for many decades, if you were going to have any sort of illustration coming from an American courtroom, it would have to be from a sketchbook artist. In 1981, the Supreme Court ruled that photographic technology had become more compact and less obtrusive than it was back in 1935. So in 1981, the Supreme Court said, we're fine with letting each of the states go their own way and try to figure out what the rules should be on cameras in the courtroom. California is right in the middle of most of the American states. This is one of those issues where we're not an outlier. In California, for there to be cameras in the courtroom, the judge, the defense, and the prosecution all have to agree. And furthermore, it isn't every camera gets to come into the courtroom. Usually it's just what is called a pool camera. That would mean one still photographer, maybe shooting for the Los Angeles Times, to give it a local example, would shoot for all the newspapers and then would have to share those photos. And then on the video side, we would have maybe a photographer from KTLA Channel 5 who would be the official person shooting the video, with the understanding that the video would have to be shared with other stations. So, if you get to the chat box, tell me what you think. Is it a good idea? Is it good for American justice or corrosive for American justice to allow cameras in the courtroom? In some way, this is the most American slide, I think, in this presentation. The Supreme Court, going all the way back to the mid-1970s, ruled that money in the form of campaign contributions is a form of free speech. The case was Buckley versus Vallejo, and it was a split Supreme Court. Buckley versus Vallejo was decided shortly after Congress passed a law that enacted expenditure limits on congressional campaigns. In other words, if you were running for the U.S. House or the U.S. Senate, there was only so much money that you could spend. Beyond that, it was illegal. What Congress was trying to do with that law was they were trying to keep Congress from being bought off by big money. Well, the Supreme Court disagreed. They felt that by restricting campaign contributions, the law was restricting free speech. The court majority said some people put bumper stickers on their cars, other people have lawn signs, and yet other people give money. The more recent decision that you've probably heard of was 2010, Citizens United versus the Federal Election Commission. The Federal Election Commission is the federal body that regulates, that oversees the presidential and congressional elections. And what Citizens United did was it built on the earlier decision in Buckley to allow individuals and corporations to make unlimited contributions to what are called super PACs. PAC is an acronym. It stands for Political Action Committee. I remember at the time of Citizens United that there were some predictions that the big money would always win. Now, I have to tell you that I'm not sure that's true. Efficacy, that's a word you probably don't run into every day. Efficacy means effectiveness. I'm not sure that super PACs are all that effective. I mean, let's go back to the 2016 presidential election. Donald Trump did not have a super PAC, at least not early on. Jeb Bush had a very well-funded super PAC. And where did that get him in the presidential primaries? And then once Mr. Trump so improbably got nominated by the Republican Party, did he have a bigger super PAC than Hillary Clinton? No. Hillary was very organized and had a very well-funded super PAC. And, we see how things worked out. I think it's appropriate to talk about free speech and students. Generally speaking, the older students are, the more free speech rights they have. And generally speaking, if they are on a public school campus, they have more free speech rights than if they are on a private school campus. Now that said, free speech rights for students are not absolute. The Hazelwood versus Kohlmeyer decision came down at the end of my first year teaching at Glendale College, and I was advisor to the student newspaper. And this was kind of a scary decision. In the Hazelwood decision, an administrator censored the student newspaper at a public high school. And the Supreme Court ruled that it was legally permissible for the administrator to do that because the newspaper was primarily a class. It was primarily a way for students to learn how to communicate clearly and abide by the rules of traditional journalism and develop the responsibility to spell words right. So what the Hazelwood decision was saying was, look, it's essentially a classroom exercise. It's not meant to be a free speech vehicle. And what made that scary for student editors and student newspaper advisors like myself back then was, yes, it's a high school decision, but that's only one step away from community college. Hosty versus Carter was a more recent decision. This was after I was out of the student newspaper, so I I didn't quite get the legal updates for this one in the same way that I did for the Hazelwood decision, but this is a worrisome decision of its own. It's not a Supreme Court decision, so that's good from a free speech, student rights point of view, but it was a federal appeals court. That's only one rung below the U.S. Supreme Court. And it ruled that some public school publications in colleges can be censored under Hazelwood. Now, that said, Hosty is a worrisome decision, but in the years since 2005, it, at least so far, has not led to widespread censorship of public college and university papers. However, I do think it is fair to say that the Hosty decision has left college student press freedom on a little shakier ground than it had been. Shield laws. A shield law gives a journalist special protection if they have, probably from a confidential source, information that's relevant to a trial. California and many other states have shield laws, but there is no current federal shield law. These laws are important for journalists. Judith Miller, a New York Times reporter, was jailed for almost 3 months because she refused to testify about one of her sources, who was considered to be relevant to a federal court case. Today, probably the biggest challenge to shield laws is who to consider a journalist. If we were to think about someone working for a large website like LAist or LA Observed, I think they would probably be considered journalists. But what about a neighborhood blogger? What about someone who tweets to their 150 followers? This is where shield laws begin to not protect people. Obscenity. Obscenity is different than the matters that we've been talking about in this chapter up to now. It's a criminal matter. You don't get sued for it, you go to jail for it. Another thing about obscenity is that it is decided by community standards. And so if that means what may be considered obscene in rural Oklahoma might not be considered obscene in metro Los Angeles, or vice versa, yes, that is exactly what it means. In 1969, the Supreme Court came up with the notion of variable obscenity. In my humble opinion, it's a fairly reasonable concept. It is the idea that if certain materials are passed between consenting adults, well, it's not necessarily obscene. But if that same material gets put in the hands of an impressionable child, well, then maybe a crime has been committed. Now that said, probably the most famous conviction under variable obscenity is pretty controversial. As you can see at the bottom of this slide, I have the cover of the Two Live Crew Nasty as They Wanna Be album. There was an unfortunate record store owner in Broward County, Florida, who sold a copy of this album, which was probably sold to minors all across the country. But this particular record store owner in this particular place made the mistake of selling this album to a 15-year-old and had to do a stint in jail as a result of falling on the wrong side of variable obscenity. The current Supreme Court standard in obscenity is Miller versus California. By the way, this is Chief Justice Warren Burger, or at least he was Chief Justice at the time of this decision, and he was part of the majority opinion, that for something to be obscene under Miller versus California, the material underwent a three-part test. 1. The material has to apply to the prurient interest of the average person. You may wonder, what does prurient mean? Lewd. This average person notion? Well, you see that in a lot of court decisions. Who decides who's the average person? Well, judges and juries, using community standards. 2. The material has to be, quote, patently offensive, unquote, in a sexual way. I remember as a student in my media law class asking my professor, what does patently offensive mean? And the professor responded, oh, just utterly disgusting on its face. Something that gets an ew sort of reaction from most people. The thing about this provision, though, that really strikes me is note that it says in a sexual way. In 1973, the Supreme Court either was not aware of or did not want to deal with incredibly grotesque violence as its own form of pornography. Third, it had to lack serious literary, artistic, political, or scientific value. I put the word serious in italics because I think what this does is it explains why magazines like Playboy really had very good articles. For example, Alex Haley, the author of Roots, a seminal look at the African American experience in the United States. He was a regular contributor to Playboy. And certainly he is in his time was a very serious literary figure. Jimmy Carter, during his presidency, one of the most famous print interviews that he gave during those years was to Playboy. So please note how those articles protected the magazine and the places that sold it from being on the wrong side of an obscenity decision. Those articles did have serious literary, artistic, political, or scientific value. As with everything else in media, obscenity changes in the internet age too. For example, if it should become a legal matter, whose community standards apply? Is it where the material was sent out of, or is it the place where it was received? While there is some anecdotal evidence that more courts are using the community standards of the place where the questionable material was received, in other words, where the person, let's say, viewing the material over their laptop or phone happened to be at that moment. Even though that seems to be the trend, courts do not have a hard and fast rule about it. As a personal matter, a few years ago, I was on a hike in the hills above Altadena. And the hike was being led by a lawyer, and we were winding our way up out of the hillside neighborhood where there was this one particularly over-the-top sort of mansion. And so I asked the leader of the hike, whose house is that? And he said, oh, that was Max Hardcore's house. And so, of course, I had to ask about that name because it's not a name a person would probably be born with. And it turned out that Max Hardcore was indeed a producer of hardcore pornography. At the time of the hike, he was doing a stint in a federal lockup. Apparently what had happened was that he had sold one of his videos, which I was assured is patently offensive, or at least would be to most people, that he sold it over eBay to a minor. Well, he lost the variable obscenity case. Copyright. Copyright goes all the way back to the beginning of the United States. 1790. I mean, we are talking about, George Washington is just settling into the presidency. The original copyright law in the U.S. protected works for 14 years, and if the copyright holder wanted another 14, they could extend it. By the 1890s, what in the United States was called the Gilded Age, international works began to be protected under U.S. copyright law. In 1976, the nation's bicentennial year, U.S. copyright law was heavily revised, and the concept of fair use was really formalized. Now, fair use is a thing that hopefully all of you will do. Fair use is when you quote something from a source for a term paper. The general theory behind fair use is you can quote as much from an article, a book, or other work, but not so much that you damage its sellability. So, a paragraph from an article, that would be fair use. 1998, the Copyright Extension Act. I think what really kind of drove the Copyright Extension Act is the growing realization that copyright holders were not so much individuals as they were corporations. And corporations can last forever. Among the winners in this Copyright Extension Act was Disney, who was able to maintain their hold over Mickey Mouse. Also in that year, the Digital Millennium Copyright Act began to extend copyright law to digital media. For you students who are looking at this audio lecture through Canvas, Canvas uses the Creative Commons. By declaring something like this PowerPoint lecture, for example, part of Creative Commons, the creator, in this case it would be me, does retain some rights, but not full copyright protection. Broadcast regulation. The Federal Radio Commission originally was created simply to keep radio stations swimming in their own lanes, so to speak. The original job was to make sure that radio stations broadcast at the right frequency and that radio stations would be limited in the wattage that they could broadcast at. This kept stations from drowning out their competing stations. In 1937, the Federal Radio Commission became the FCC, the Federal Communications Commission. And in part, this was an acknowledgement of the coming of television, but also of what other electronic media may come after that. So its job was to regulate all electronic communications. The Telecommunications Act of 1996 has made 3 appearances in MassComm 101. You may remember it from the audio chapter, from the television chapter, and now, in what is probably overkill, I'll talk about it a 3rd time. This massive law began because President Bill Clinton wanted to have a way for parents to block out television programming that they didn't want their children to see. And for Mr. Clinton, this seemed to be having it both ways. In other words, with the so-called V chip, V stood for violence, it would give programmers the right to push the envelope on uh, challenging adult programming. On the other hand, it would put increased power in the hands of the television consumer to say, I don't think my child is ready for that show yet, so we will have an electronic way of zapping that out. Well, in order for President Clinton to get his V chip installed in all new televisions, and the rating system, the television rating system that was linked to it, well, as you no doubt know, it is not the president who passes laws, it is Congress. And so there was a lot of revision and additions. And I think in the end, the Telecommunications Act was about these other things a lot more than about the V chip and the rating system. One thing that the Telecommunications Act did was it came pretty close to deregulating the number of stations, radio stations, that one person or one corporation could own. I mean, up to 8 stations in any one market, that's pretty close to no capital. The cap on television stations is tighter, but not as tight as it was before this law. So one entity can own television stations that reach less than 39% of the nation's TV homes. There's also some deregulation in this law in terms of what communication companies can do. So what this did was it freed telephone companies to offer cable TV services, and it would only be right to go the other way too, to allow cable TV companies to allow telephone services. And you would wonder, well, why? The idea was to create more competition so that cable rates would not need government regulation. Net neutrality. I think in understanding net neutrality, it is important to look at this through a politically partisan lens. In general, Democrats are in favor of net neutrality. In general, Republicans are against it. So, 2009, President Obama has just taken office. The FCC has a majority of Obama appointees. And the FCC started working on rules that would ensure so-called net neutrality by requiring the ISPs, the internet service providers, to allow all websites to load at the same speed. In other words, not to have lanes for big websites that could pay the ISPs extra money to load faster. I think that's probably the fairest way of putting it. The internet service providers say that while net neutrality sounds good in theory, they believe that in practice that those big data-hungry sites should pay extra so that customers can have the right to stream video and other data-hungry things. The net neutrality advocates are concerned that the lack of net neutrality puts the internet service providers in a very powerful position. I mean, the net neutrality advocates say that the ISPs can, in essence, charge people coming and going, that they can charge the Netflixes of the world extra to have their data-hungry material load quickly, and then they can also charge their internet subscribers, their customers, more money for fast greater bandwidth. (2017). Please note this is shortly after the election of Mr. Trump. The FCC, now in control of Trump appointees, threw out the Obama-era net neutrality regulations. In 2018, after the House of Representatives came into majority Democratic hands, legislation was introduced to restore net neutrality, where it stalled in the Senate.